Good evening, everyone. Thank you for joining the Health Law Society at the Roger Williams University School of Law. My name is Aurora Paradises. I'm the president of the Health Law Society, a 3L at RWU Law, and a certified mediator. I've also enjoyed a rewarding career as a healthcare clinician, college faculty member, and healthcare executive over the past 2 decades. I'm your program moderator this evening. We're very excited to engage the legal community in our first health law forum here at RWU Law. If you have questions throughout the program, please enter them in the Q&A. We will address all submitted questions toward the end of the program. We have an impressive panel tonight. Thus, without further delay and in no particular order, let me introduce David Godfrey. He is a senior attorney at the American Bar Association's Commission on Law and Aging in Washington, D.C. He is responsible for the ABA's role in the Administration on Aging's funding, National Center on Law and Elder Rights. Prior to joining the commission, he was responsible for elder law programming at Access to Justice Foundation in Kentucky. Mr. Godfrey earned his Bachelor of Arts with honors at Rollins College in Winter Park, Florida, and his JD cum laude from the University of Louisville School of Law in Kentucky. He served on the board of the National Academy of Elder Law Attorneys and was named a fellow of the Academy in 2019. Welcome, David. Next is Diana G. Santos. She is the Assistant General Counsel at Memorial Sloan Kettering Cancer Center, where she reviews a large volume of agreements related to IT and data products, solutions, and services. She collaborates with other attorneys and business stakeholders to address information, security, privacy, and data issues. Prior to joining Memorial Sloan Kettering Cancer Center, Diana was associate counsel at the New York Genome Center, where her responsibilities included drafting, structuring, and negotiating a wide range of contracts, providing legal support to senior leadership in the C-suite, managing intellectual property, as well as addressing data privacy and compliance issues. Diana also spent many years in big law as an associate. She advised on major software, hardware, e-commerce, technology, investment, automotive, biopharmaceutical, and consumer product companies, as well as startup companies. Through transaction and litigation, she led teams addressing a variety of IP issues relating to commercial agreements, M&A, branding, patent, trademark, copyright, and domain rights. Welcome, Diana. And last but certainly not least, we have Misha Woodley. She's an associate attorney at Dowling Law, PLLC, with over 20 years of interdisciplinary experience in law, healthcare, business, and education. She provides legal, regulatory, and compliance services for stakeholders in diverse industries with a special focus on healthcare and human services related issues. Over the past several years, Mishka worked as a government relations and regulatory attorney representing diverse for-profit and nonprofit entities by engaging legal, administrative, and legislative strategies. Mishka facilitated negotiations with government agencies and legislative leaders regarding complex issues, including the corporate practice of medicine, scope of practice, cannabis legalization, referrals, conflicts of interest, and regulatory violations. Mishka currently serves on the New York State Bar Association's House of Delegates and is a member of the Health Law Section's COVID-19 Task Force. She also serves as a member of the Albany County Bar Association's Board of Directors as a co-chair of the Albany County Bar Association's Diversity Internship Program. Mishka strongly believes in the profound value of authentic relationship building and mentorship amongst diverse individuals in the workplace and beyond. Beyond the office, she dedicates her time to those efforts. Welcome, Mishka.
Thank you for having me.
We want to cover as much ground as possible for the audience this evening, so let's get started. To all of the panelists, would you please inform on your career trajectory and how an intersection with health law has played a role? I know I went through your bios, they're very impressive, but how would you describe they intersected or came to intersect with the health law arena? Mishka, you can go first.
I can go first. So my name is Mishka Woodley, and I am currently, we joke about kind of titles, right? So I do healthcare, regulatory, and kind of compliance law in my practice area. And I currently work for a law firm that does focus in that area, as well as labor, employment, human resources, things of that nature. And so over the course of my career, I've worked in with a number of different industries, whether it's automotive or a lot of startups, finance, restaurant, food and beverage. And when engaging in a lot of those different industries, a lot of them have healthcare issues, whether it's related to something like COVID-19, but it's also ADA issues in terms of compliance. You have compliance issues related to just healthcare and access to healthcare for all of their employees, and that it's distributed in an equitable way in terms of leave policies, and that they're compliant. And even in the regulatory space, being a government affairs attorney, healthcare has touched so many things in terms of just a lot of businesses. There's nonprofit and for-profit entities working together to engage in healthcare related business, such as right now we have COVID-19 testing, we have Walmarts that want pharmacies in them, whatever the case may be. And so there's been a lot of crossover there. So it is fascinating how, especially when it comes to labor and employment, a lot of corporate law, there's a lot of crossover in those spaces. In real estate also as well, in terms of just shared property and how rents and things of that nature can be distributed and utilized for that space.
Sounds like it really runs the gamut. Diana?
Right. I think that was exactly my sentiment. I'm glad I'm not the only one. I'm not a health law practitioner per se, right? But I practice in the health law, and I guess I found myself in this position because I like technology, but I've always enjoyed the ultimate goal of helping people. So it's kind of like all my favorites got meshed together in the roles that I've taken on after leaving, big law, even when I was in big law, right? All of like the pharmaceutical companies, in one way or another touch health law, right? So like in the pharmaceutical space, I found myself learning about FDA regulations, which, you don't use when you're, for example, representing an automotive company necessarily, right? And then currently, especially with COVID, when I was at the Genome Center in that time frame, it's a small organization, and we found a small group of attorneys, the three of us that are there, basically diving into a whole new world, right? And so even though your primary hat might be one thing, health law intersects with all that we do, right? Whether it's because you're thinking about genetic data and how that's used, right, from a regulatory perspective, or you're thinking about your employees. And then today, fast forward to my current role at MSK, and it, everything that I do relates to health, right? The whole purpose of my contracting work is to provide products and solutions to the hospital that can help people.
Yeah, that sounds like wonderful work. David, so you're in the elder law space, but you don't consider yourself to be a health law lawyer. So expound upon that a little bit.
But there's certainly a lot of overlap. The first call that I took after I passed the bar exam was a referral from hospice to do a house call to do advanced healthcare directives and talk about end-of-life healthcare decision-making and options for a hospice patient. So most of the work that I've done is probably on the consumer side. In the office that I'm in now, we do a lot of research on and training and education on healthcare decision making. Who has a right to make healthcare decisions? How are they made? What do you do when the patient can't make or communicate a decision? And that brings us into the sphere of looking at capacity and assessing the person's ability to understand the decision that they're being asked to make. And then the alternatives. I've spent about 4 hours today working on development of on planning for a guardianship summit. And one of the issues that comes up in guardianship is healthcare decision making. Can the guardian guardians are frequently appointed because somebody's needed to make healthcare decisions, or somebody's needed to file a Medicaid application so someone can be transferred from an acute care hospital to a long-term care setting, and they need someone who can legally sign that. So we really work on it from the patient or the consumer side, but there's a lot of overlap between the elder law sphere and health law, because a lot of the legal issues and legal challenges in elder law come up in healthcare and money.
Yeah. And that's where it always resides, right? But it's interesting. So we've mentioned health law several times this evening and have shared some meaningful, pre-program exchanges regarding how difficult it is to define the practice of health law. Is there an actual definition for health law? We'll start with Mishka.
So we did. We had a discussion on that. So it's funny. So after our discussion, I reached out to a number of people who are either leaders in the bar or otherwise are health lawyers. And I said, so how do you define health law? Because we had this somewhat controversial discussion about it in a casual way. And so it was interesting getting the different perspectives, right? And then, so I had one person, and I actually wrote the note, and who said, I see health law as interpreting laws that govern the healthcare system, and it doesn't matter who we represent, whether it's a consumer or the patient or the facility. And then another person said, well, actually, I primarily think it's people who represent like more so the facilities, the insurance companies, like it's more so the institutions versus the patients, because the other people would be patient advocates. And so I went on the ABA's website to see how they defined their health lawyers. And they said they represent clients in all segments of healthcare and industry, but then they list only the providers and the hospitals and the healthcare providers. So it says providers, hospitals, institutional providers, research organizations. So I think it's really eclectic. I think it depends on who you speak to. But in terms of health law, whether you want to call yourself a health lawyer or not, I think the scope of healthcare related law is so broad. We do cover everything from elder law and corporate, and you do have your cannabis law now, public health law. Sometimes people really don't look at that policy side and they forget about that. So it really does run the gamut, and I think it's expanding. Like Diana was saying, with technology now, I just did a cybersecurity presentation, a few weeks ago, and we had a privacy issue today. I was telling them related to, law enforcement accessing information for a facility and that battle that we're going through. And so, it really does touch everything in some capacity. I think it just depends on how much of it is the healthcare piece versus just a consultation, related to health information. And medical malpractice has also been the controversy, right? Are you a litigator or are you a healthcare lawyer? And then he will say you're a litigator to, you educate yourself in the space of healthcare. But then there's some who will say, well, it falls under the health law umbrella, and so you could still be considered, in that health law space.
Very interesting insight. Diana, do you have anything to add?
Yeah, I think it's interesting because I think I started, right, like a few minutes ago saying I'm not really a health lawyer. Now I'm thinking, like, am I? But I'm thinking from the pure like legal perspective, like, right, my client is MSK, right? But one thing that is very clear to me about MSK is how important patient care is, right? And so even when, and it was probably ingrained in me within the first hour of being at Memorial Sloan, like there's usual training, but there were a lot of people who separately, and I don't think they coordinated this, were like patient health care is first. Anything patient care is first. And that's the way, it's proven true that this is how we operate, like, and this is how we think about what we're purchasing, and this is how we're thinking about patient data. And so maybe I am a health care lawyer or health lawyer. I don't know what to call myself, but but the I guess, there's so much emphasis on making sure that we are benefiting the health of the patient, right? Like, so if we buy your product, right, you are thinking, for example, like your cybersecurity, you're making sure that it's secure. But then ultimately, many times I'm also thinking, like, what happens if this product goes under, right? And it's a solution that, for example, tracks something about the patient or incorrectly identifies or diagnoses, right? Now that we have a lot of artificial intelligence, incorrectly identifies or some condition, right? How are we thinking about it, and how are we putting the patient first and everything? So maybe I am a healthcare lawyer.
Well, I tell you, as time goes on, I guess we'll all figure it out, right?
Yeah.
And,
Go ahead, David.
And I think there's a lot of areas in the law where we have to be careful to not silo ourselves of being a particular type of a lawyer because it's so interconnected. Tax law. How does tax law interconnect with it? From the consumer standpoint, if a physician prescribes it as care, it might be a deductible medical expense if it's not covered by insurance for the consumer. I remember one of the cases I read in law school and tax law about installing a swimming pool in somebody's backyard because it was necessary for physical therapy for maintenance of the health and wellness of the individual. And it was actually a successful case of writing the cost of a swimming pool off as a tax deduction by the consumer. So is that a health law issue? Is it a tax law issue? It's both, because if you don't have the right paperwork, the right orders from the physician saying this is medically necessary to maintain or improve the health of the patient, it's not a tax deductible item. It's not a healthcare expense. So it's all intertwined.
Sure. Very good point. Very good point. So to shift the conversation a bit, we could not responsibly have this discussion without touching on some aspects of the impact of COVID-19. So, Diana, how do you think COVID-19 has changed the healthcare system since you work for a healthcare entity?
It's my whole reason of being, I think, in some ways, because the role that I have didn't exist before, right? And so basically, there's a contracting team, right, who previously managed all these contracts, and then the explosion of, it's not so much the explosion, I should say, it was always planned, but COVID accelerated the plans to have a digital transformation at the hospital. And so it created this need to have somebody with the expertise and technology to support this new, quote unquote, it's not really new, right, but this growing section of the hospital, right? It's not only that, at least with MSK, I don't know how you guys are familiar with it, right? It may have been seen in the past as traditionally a New York hospital, but really with the digital transformation and the expansion of all the digital initiatives of the hospital, it can't be viewed that way. Like, I don't think a consumer would look at us the same way. A potential patient or a consumer who's just looking for information would look at Memorial Sloan the same way.
Yeah, that's a good point. So I know, David, that you are intricately involved in the COVID-19 vaccination program as it relates to the elderly population. So in that context, can you talk to us a little bit about consent and what is informed consent and why is it important, specifically tailored to the vaccination program?
Yeah. For lawyers, we actually have a definition of informed consent in the model rules. And it's an agreement by a person to a proposed course of action after communication of adequate information and explanation of the material risks and reasonably available alternatives of the proposed course of action. In other words, the person has been told, there are options. These are the risks and benefits of the options. These are the long-term consequences, and then been asked to make a choice. Is this something you wish to do or not do? And informed consent is one of those core things in medical treatment. With the exception of emergency care, you're always looking for informed consent. Care without consent is a battery.
Okay,
First year tort law.
sure, sure. So to that end, what are some of those elements that go into informed consent? And again, let's narrowly tailor it to the COVID-19 vaccination program.
Yeah, for this, I'd actually go, does the patient, the client, or the patient understand that COVID is a serious viral infection that people get seriously ill from and might die from? That there is a vaccine available, or a variety of vaccines available, and that those will reduce the risk of getting sick. And the research shows, for the most part, that if you are vaccinated and you are infected, that it will likely be less severe. That a small percentage of people have an allergic reaction to a vaccine. And if somebody has a history of allergic reactions to vaccines, that they should talk to their doctor about whether it's safe for them to do. And that if you when you have the vaccine, you may have some side effects from it. I had my second shot on Saturday and spent Sunday in bed recovering from it, feeling achy. But that's my body responding to it. The immunity from the vaccine may not be long term. And these are new varieties of vaccines. Traditional vaccines have been around for a long time. I was reading a book, A History of Medicine, in the middle 1800s, and they were vaccinating against smallpox, which was live virus vaccination. Scary stuff we don't do very much. I don't think medicine does very much anymore. I'm not an immunologist or a doctor. But this is a new type of a vaccine and a new technology. And no, we don't have a 40 or 50 or 100-year history of how does it act in the body. There was a piece on the news over the weekend of blood samples drawn from people who survived the 1918-1919 flu epidemic. And they went back and isolated the antibodies in their bloodstream that were formed 100 years ago when they were infected with that virus. So we know we are able to study long-term effects of viruses, and certainly the DNA analysis that's going on is giving medicine, opening new frontiers and new understanding. But if a person understands those elements of what it is, and they say, yes, please give me the vaccine, they've given informed consent. I always think it should be done in consultation with a healthcare provider that's familiar with your health and your health issues, because there are risks. But yeah.
So let's talk about somebody, let's say a patient who lacks the ability to give consent. How would you manage that scenario?
Yeah, the patient always comes first. And this is something that we push on real heavily, especially with adults with diminished capacity, that the patient should always come first. And we should always try to do our best to communicate with the patient, with the individual. But that's not always possible. About 44 or 45 states have statutes that say if someone is unable to consent to medical care, who can? About 40 of them are next of kin type statutes, and there's 4 or 5 of them that are unique to those states and the way they describe it. Our research has actually shown that healthcare providers, even in states where there's not a default healthcare decision maker statute, usually will turn to trusted family and friends that are there showing a genuine interest in the patient. They act as though that default healthcare surrogate statute existed in their state, whether it does or doesn't. And as one of them pointed out to me, remember, when he said, this is a physician, remember, David, I went to med school, I didn't go to law school. So good point. But their concern is to make sure that someone is consenting, that that appears to have the best interest of the patient. We encourage people to do advanced healthcare planning, to name a healthcare agent or surrogate in writing before they need it, to discuss with that surrogate and with their family members what their personal healthcare values and goals are. Healthcare is very personal. I had one grandmother who was a strong believer in medical science. She had a shoebox full of pills, and there was something in there that would cure everything. She went to the doctor at least once a month and frequently once a week. And another grandmother who saw a doctor about 5 times in her life. She wasn't a believer in modern medicine. And when we're making healthcare decisions for these people, when they're unable to, they're too sick, they're injured, an illness has occurred, we want to try to reflect what decision would that person make if the person were able to make the decision for themselves.
Very good point. And certainly preserving, dignity of patients is above all else.
Yeah.
So, Mishka, you offered us a little bit earlier sort of a gamut of where healthcare law potentially can intersect, and Diana sort of supported that position. So, do you see any new or emerging issues outside of COVID-19 where health law intersects with a number of other practice areas?
Yeah, so, especially here in New York, and I'm sure, Diana, cannabis is the word of the day, right? It's a perfect example, I think, right now. We legalized here in New York just a few weeks ago. And so it crosses so many different practice areas. It's actually really fascinating because you also have legalization for recreational / adult use here in New York. And then we had medical marijuana that was legalized and is utilized in our state. And so when you think about labor and employment, and you think about what do we do in terms of drug testing in your work environment, we talk about patient safety when it comes to individuals who might be using and testing, when it comes to insurance and insurance liability, whether it's insurance liability for an employer or just generally auto insurance liability. I know New York State, it was really controversial about what do we do about driving and criminal investigations, right? And testing at the roadside. And so they didn't even really make a decision in that space. They're going to have DOH, and they're going to have a lot of different, a lot of research done in this area to ensure that they find the appropriate testing mechanisms in order to make any, any testing criteria that they establish equitable and non-discriminatory. I guess that's the overall goal. But in terms of like banking, and you have the FDA, and we didn't really talk about the FDA, but we kind of did touch on it. The fact that that's kind of health law indirectly, right? So, that drug regulation. So now you have e-commerce, and you have regulations related to banking, and can you, where does the money get stored if it's illegal? So it touches all of these areas, and everybody kind of needs to be at the table, and everybody is not at the table at once, but especially because we have patients, as Diana was saying, and like David, all of this is patient, there's a patient emphasis here outside of the commerce portion where we talk about the funding and the taxes. So in the midst of all of this, beyond people who are doing it for a more adult use recreational piece, how many of our medical patients get mixed up in the midst of all of this and end up being disparately impacted as well? So it will be really fascinating as we move forward how it all plays out for both medical patients, but then also just everyday individuals who now are using a substance that will be deemed legal in some aspects, but illegal technically in others based on federal law. And then even as they're using it legally, are they going to be equitably treated when it comes to testing as compared to maybe other drugs that are now illegal and it used to fall into that category?
Yeah, I agree with you. I think it is going to be fascinating to see the evolution. We sort of have a little bit of insight in, looking to Colorado and how far they've gone in terms of the developments, but, New York is a different culture, so we'll see. So Diana, to dovetail onto that, in the digital space, can you inform on the transformation of the digital space and the dimensions that may add to intersections with health law?
I think it's in everything. I mean, you see it, right? Like, I'm trying to think, like I was younger, for example, like your copy machine was just a copy machine, right? Like it was just like you put the paper, you copy it, and that was it, right? Now that is not how anything works. There's really like that whole internet of things. So there's the way you connect, via the internet, and you're touching portals and you're logging in your information, patient data, and you're consenting to certain things, all using, right, digital technology, right? But then there's also in the actual like physical things that are used in the hospital, it's all interconnected. So your machines now, for example, might, much like cars, right, send out information to the original manufacturers to tell them whether something's wrong, right? And then the question becomes, well, what information are you giving them? so it's literally in every single thing that I do that I'm thinking ultimately about the patient data, right? What data are you getting and how are you using it? It's so valuable to the patient, and it's valuable to research, right? And to the ultimate goals and missions of MSK, and I'm sure of other hospitals and other healthcare centers that, we see this, evolution. I mean, I'm not even sure what to imagine that healthcare will look like for me when I'm old. Like, will I even be in a hospital? There's a chance that I won't, right? Like, I will hopefully, like, yes, I have a nice, healthy, aging process. But like, what if you end up needing what today requires, being in a hospital long term, right? That might not be the case in the future. It might be possible that you have machines and devices and ways of communicating with doctors that may give you even a better environment in the sense that you're probably maybe with your family members as opposed to like isolated in a hospital for a long term. It's just, I see it evolve month to month, to be honest, about like what vendors are providing and what projects people are thinking of. And sometimes I just like can't believe this is all happening, even though I'm not even that old. I'm like, how is this possible? Like, what is it? I can't, like I said, I can't imagine what the future, what it's going to look like in 20 years because it's moving so quickly.
Yeah, I'd love to say really quickly, dovetailing on that, is that I think it's so critical for all like health lawyers or people who touch that space to be participants also as educators, because as you said that, so my struggle all day was that concept of what's the definition of a record, and everybody thinks of a medical record in a chart, and that battle to talk about the text messages and the devices and the world, everybody sees it very differently. And also people think, oh, it has to have a name and all of the contact information there and the medical information. But that's not what the rule is anymore, and it's not the world that we live in. So I just wanted to say that because I agree 100%.
And that's not even to address the fact, just to piggyback on that, to address the fact that there, like, whatever laws are, there's still like laws I think being considered on like genetic data, right? Like you again, not the typical healthcare lawyer, but like what can you ever, for example, de-identify your DNA? Like, it's not possible, right? So what are we doing there? What are we doing in that space? How are we protecting it? How are we protecting it so that maybe if I have, I don't know, some service sequence my DNA today, that when I'm 70, that for some reason some insurance company can't get their hands on it and say, nope, you're not insurable because you're likely to get all these, diseases, right? It's possible. And there's such an evolving space. I mean, the truth, what I operate is, don't give out your data. Like, I do everything possible not to give out my data. I don't let my car track me. I don't care if the navigation system doesn't work. I just am too nervous about the whole thing because like I said, I can't imagine what it's going to look like 20 or 40 years from now.
Yeah. And the flip side of that, on the healthcare decision-making side, for years we've done paper advance directives, and then they can't be found, or they're buried. They're 300 pages into somebody's medical file, and it takes the staff 20 minutes to find that tab and dig out the advanced healthcare directive and find out who's named to make healthcare decisions. In the meantime, we're trying to decide whether this person's should be resuscitated or not. We're seeing this year an increasing number of states that are proposing electronic wills, and some of the electronic will statutes include electronic healthcare advance directives. If we start creating healthcare advance directives, naming a healthcare surrogate and leaving directions about CPR, end-of-life care, life-prolonging care, will that integrate into your electronic medical record system so it can be found? My family's experience when my mother was in that position was I emailed the PDFs to my sister, and the hospital wouldn't take them by email. They told her to go home, print out the PDFs, and bring her back paper.
Well, all very interesting. You know, I see my professional coach here in the audience, and I know he and I have had some conversations about this. He is the vice president at Hudson Bay. I don't want to put you on the spot, Mr. Bailey, but you want to say a few words about, you know, this topic?
All right, frame the question up more specifically, because I know we've talked about a lot of stuff.
Yeah, so I was specifically thinking about you when Diana was talking about, you know, the data. You and I have had conversations about the wearables and the biometrics,
Yeah.
and, you know, the collection of all of that. So talk to us.
So in a former life, I worked for CVS Health, and one of the things that obviously is driving healthcare is value-based care. So as a provider, you're trying to show that the different things that you're doing, programs, initiatives, are driving value to adherence and improving the health outcomes of the different patients. So things like giving out a free Apple Watch that has already been staged with, like, you know, you say you have diabetes, and it's staged with workouts and encouragement and different biometric readouts that then ping back to, say, Aetna, because it was in light of Aetna being acquired by CVS. So we would now say, one, how are we able to measure and show that these programs drive adherence to the care plan, improve your health outcomes, and by doing that and reducing the number of additional interactions with medical professionals that are emergent, so like having to go to the ER or other types of, you know, adverse outcomes because you're not following the directions from your doctor. How do you measure that? And the wearables was a way to measure and monitor and send back that data on a regular basis. So the challenge was always, there were companies that had really good apps that were, you know, digital therapeutics, and then we had the patient data and the ability to push a lot of patients to the apps as well as the wearables. So the fight was who owned the data. And obviously the companies that developed the apps, they wanted to own the data. We felt the data was proprietary and valuable to CVS, and I'm sure they still feel that way, even more so today. But the fight over data is significant because there's significant value in data. It really instructs how you can come up with new products and drive value and you know, differentiate yourself as a company from your competitors. That data is becoming extremely valuable. So that's one of the conversations Kim and I had, and it's something that I don't think has been fully resolved. It's evolving, and it's going to be more and more fought over by companies, but that's the angle.
Yeah, and I'll just add on to that a little bit, right? Because it used to be, right, I think even maybe 10 years ago, right? Maybe when I first came out of law school, it used to be like the biggest things that you would focus on, you know, in our contracts class, right? Would be like, you know, obviously the actual words of what your agreements or representation, warranties, et cetera. And then indemnity and liability, right? Like that's what you would deal with in the contracting space. How, you know, what are you going to get indemnified for, and how high is the cap? Is like that. That is no longer the case. I will tell you that from experience, I want to say, I haven't done the math here, but I would guess like somewhere like 30% of the conversations that we actually have with all these vendors who are trying to sell us something is about the data, right? Like who has the data rights? And then it evolves into a really complicated discussion, especially when you have patient data, right? PHI. And that's where I start waving my white flag to my specialists in the team to say, I needed a little help navigating all this. What is acceptable, right? What is generally like the hospital stance, right? It's no, you don't get our data. That's the general stance, and I think that's the stance Colin was talking about is the CVS, and anybody I think who knows the value of their data will say you can't have it. You can only like use it for purposes of providing us a service or for a very limited purpose. And then it becomes sometimes I have 12 people on a phone call, right? On both ends. You've got business people on MSK, right? Representing what it is that we're doing with this particular solution. We have our kind of regulatory lawyers who deal with HIPAA compliance, and sometimes it's GDPR or something else that's at issue. And then you have the vendor then bringing in their data specialists, because sometimes even the legal and the business team on their end doesn't exactly know what data they're asking for, what they do with it, how they aggregate it, how they de-identify it, whether they can delete it. It's a plethora of questions. And, I am just shocked. I guess I'm not shocked. I think it's just, I'm amazed by how much worse that aspect is getting over time. Like that is just getting more and more challenging. And I think becoming one of the key factors in, the digitalization of health is what do we do with the data that we're collecting?
Yep, I agree. And just to put a button on it, because I'm not going to let Kim pull me into the panel, but because you guys are doing a great job, is we, as the, like, say, originators of data, hospitals, the CVS with the pharmacy and the insurer, that we're not good at apps. We're not good at some of the distribution channels of the data, to the public or to the patients. So we do need to partner. We have to work with third parties to figure out how to get it out there, these great ideas. But at the end of the day, we do want to own all of our data. And I think it's going to continue to be a challenge. And it's going to get to a point where some of these distributors are going to be powerful enough to flip the paradigm and say, you don't get to this audience without me. You need to share rights of ownership. And I think right now the power is in the hospital, power is in the CVSs of the world, but it's going to flip eventually. And it doesn't need to be a huge company. It just needs to be a company that's penetrated the market, and a lot of name recognition is there and brand recognition is there, where folks want to use the application or the wearable that's connected to an application to better their health.
Say it isn't so, Colin. Say it.
Well, thank you so very much, Colin. I didn't mean to put you on the spot, but when I saw you in the audience, I said, I can't resist. I mean, we've had this conversation. I got to get him to sort of share. So thank you very much.
No problem.
Okay, so that was a very interesting discussion about data. And as we all can readily identify, the intersection is very clear, and it only gets more complicated. So to expound on the salient points that were just made, let's discuss the unique ways that healthcare lawyers may be useful in other practice areas. So Mishka,
And actually, and I'll say really quickly, so I know with the data, and I think I saw a question where someone was asking about 23andMe. And so I think the way that companies like that do handle these issues, I don't know, I can't speak to how well they're handled, just because of kind of the chaotic nature of sometimes the law not catching up with the technology that everyone was just speaking about. But typically what does happen and can happen is you end up having health lawyers who help with, so I used to work in government affairs, regulatory, and lobbying. So I used to have a client who was a well-known biometrics company that's used nationally and internationally. And so, in terms of data, what can be collected, under what circumstances, what are the implications, what are the policy implications, just in the short term and the long term, and getting healthcare advice related to that, and any regulations that might govern, like they were saying, the housing of the data, what are you capturing, what's in your consents, how long is the data held, do you have to destroy over a period of time, and especially when it comes to law enforcement, when you talk about biometrics, genetics, how can that information be used, and can it be subpoenaed or something one day and used against someone, especially when we're getting biometrics and genetic data from children or people who do not have the ability to consent. So you have kind of that policy side and that regulatory side. What are the regulations? But then you also need people in that corporate practice of medicine, corporate space, to really work on those contracts, as they were saying. So making sure that your contracts, your consents, every one of your documents conveys exactly what it should convey, aligns with the law and the regulations, and it's also clear. So your patients and your individuals understand exactly what they are consenting to, and making sure that when you implement, that you are implementing appropriately. And so very often they might bring people in to do audits and review their policies, make sure that they're up to date. If an issue arises, get both not just litigators or general counsel, but individuals who have that healthcare experience to be able to bring in that nuanced perspective of, this is not getting Nikes. And so if you have a disgruntled customer, this is what the outcome can be. It can actually be extraordinary for you because of the nature of the product or the individual who you're having an issue with. So I think it's really sketchy though right now in terms of how it's being handled, because I feel like generationally there's a perception of, well, we don't have privacy anyway. So we have a lot of people consenting to a lot of things, but it's not clear and they really don't know what they're consenting to. And we really don't know. It's the first generation where so much information is shared from the time that you're a child, that how will this work for you and how can it be used, like she was saying, when you're 25, when you're 30, when you're 50, something comes up and they can just pull your data because it was given when you were 16, right? So we're not really clear exactly, but that's why this is such a great practice area, because it touches all of that. And if you like contracts or regulatory or policy, you can touch it from any angle.
Or if you like IP, right?
IP, exactly.
That's my training was intellectual property, right? And it was more patents, copyrights, trademarks, trade secrets. And then I found over the last, but basically since I went in-house and worked at the, the New York Genome Center, which is a research center now at the hospital, the IP knowledge is basically what really is instrumental when I am negotiating what rights are, because I think that sometimes people aren't thinking about IP, like data as IP. They usually call vendors or suppliers usually think of call their special IP counsel in for discussions when, for example, they're talking about work product or inventions. And I'm like, no, you also need to think about it when you're thinking about data, right? What is who owns it? What license am I giving you? And then what words are you using to convey that license, right? They're very specific terms. And if they're not defined, define them. But you have to have on that ownership cap on your head when you're negotiating those rights to understand what it is that you're actually doing. So I think, if that's the space that somebody's interested in, intellectual property will serve you well.
That's great. That's a great point. I do see some people in the audience in the alternative dispute resolution space. Are there any prescriptive, sort of recommendations you have for them related to if a health law issue arises during an alternative dispute resolution, but that's not the focal point of the dispute? What should they do if they don't have that expertise?
So can I ask a clarifying question on that?
Yeah, sure.
So is it the disputes are ready in ADR and then
Correct.
And you have to stay in there? The former litigator.
Well, we're back in law school, so let's say the hypo is you got to stay.
Stay. I'm sorry, is what I would say as the litigator in me. And I think in ADR, the concept would be, right, I think that if you, having gone through this process and not liking it, as you can tell, would be that you need to make sure that whoever is on your panel, right, whoever your mediator is or your moderator is, and whatever panel you're putting together for this dispute resolution knows what they're talking about, right? That is the key number one, right? So you have to make sure that again, so if you're thinking about some health law issue, but you also have, I don't know, data issue, and then you have a consent issue, then you need to make sure that who you're dealing with has full working knowledge of all the aspects. That would be if you're stuck there.
I think especially because in healthcare, when you're dealing with, so I know of a client right now where you had someone who was dealing with a professional license, the removal of privileges from a facility. And then depending on the removal of those privileges, it can impact your potential ability to be reimbursed for insurance, depending on when it comes to providing services, depending on why your privileges were pulled, and is there some sort of, you know, medical professional misconduct there. Like, there are all these kind of nuances in the healthcare space where a facility, there's healthcare fraud, there's anti-kickback, and what that looks like in the healthcare space versus another. And so I think it's really critical, especially as we do have more for-profit entities who never really focus on healthcare related issues or kind of business collaborations in the healthcare space, that they can find themselves in a situation when they're engaging in either a legal activity or a dispute that's more nuanced, that they don't really understand the full implications of. So there's even one we're resolving now where, you know, the implication of something that wasn't resolved could actually result in all of these other things related to that practitioner, that I don't think anybody even really thought about, because that wouldn't be typical for another, you know, another profession.
Sure, sure. David, any thoughts?
On the consumer side, places where we see it, family disputes over placement sometimes go into mediation or alternative dispute resolution. You know, the payment for services issues are primarily administrative hearings, and that's really its own little world. I've not run into any consumer health insurance contracts that went into arbitration, although long-term care facility contracts frequently contain alternative dispute resolution clauses in them, so that if a dispute arises between the consumer and the facility, a lot of the contracts refer to alternative dispute resolution. And there's been a 20 or 30-year fight between consumer advocates and the healthcare and the healthcare providers about getting those clauses, whether they're enforceable. And that's actually an interesting area of litigation, if you want to go read cases, is the ADR clause in the nursing home contract enforceable or not? And it depends on who signed it and in what capacity they signed it, and whether they knew what they were signing or not. And then I think of, you know, my mother spent some time in a nursing home, and I was in the office with my father when he signed all the admissions contracts, and it was kind of a, don't bother to read them, just point to where I need to sign.
Mm-hmm.
You know, Dad, maybe I should read those. Nah, no, she's not ready to come home, and that's what they want me to sign for her to stay here, so I'll sign it. But those are, you know, are things that come up. So that's where we see ADR on the consumer side primarily, is long-term care contracts. In-home services contracts from home healthcare providers or physical or occupational therapy providers will frequently have ADR clauses in them that have to be exhausted before you can go to litigation.
Thank you for that, David.
I think too, especially when patients are involved, you know, and you're trying to resolve a matter with the healthcare facility, I think especially depending on the type of facility, the patients and their families, the dynamics are very different depending on the issue. And sometimes when you do bring in or find somebody who has experience with that type of practice of medicine, that type of facility, that population of patients, whether it's age, as he was talking about, children, family, I think that sometimes getting that additional perspective can kind of help also mitigate some ongoing conflict, because it can be really nuanced. And as we know, very often medical malpractice, you know, a lot of those claims happen because there was just beyond something that happens badly, but there's just a disconnect between the communication with the family or the facility or something of that nature. And it's really just finding someone who really understands what's going on and what may have happened, and like that culture of that facility and that experience, who might be able to like soften that dynamic and create more of a trusting relationship, because they feel like you know what you're talking about, versus trying to you know, pigeonhole everybody in the same patient facility category, because they're all very different. I think a nursing home is different than, a children's hospital.
Yeah, I totally agree. And having come from the space, I was a former vice president for nursing at a nursing home, and you're absolutely right. Oftentimes the families just wanted to, sort of let their grievances be known and be assured that somebody was going to do something about it, and that in 9 times out of 10 is extinguish the issue. So absolutely correct. So I can't believe that we're almost out of time. I could talk to you guys forever, but obviously, we don't have that time this evening. So last thoughts, call of action, or thoughts related to this intersection with health law and what to do about it, if anything. Diana.
Yeah, I'm thinking just don't stop learning, right? I think that's really what it comes to. The practice here is evolving so quickly. I had somebody in the hospital tell me, when I joined, I was talking about like legal operations, and I said, what could I do to improve legal operations? They didn't quite answer the question, but this is what they said. They said, one day in contracts is like 10 days in technology. So meaning that if I'm not working 10 times as fast, I guess I'm too slow. And that's very true. That's very true. That's how critical and how quickly the space is developing. So do what you can to stay informed, because what you may be looking at is just like that iPhone, that or whatever it is that you have, that your handheld device is today to handle your emails, your texts, your social media, may be the thing that you're using to monitor your health, right? Like more so than you're thinking about now. So yeah, stay awake and be an active learner.
Thank you. David.
Yeah, if you're wearing an Apple Watch, you're already wearing a medical tracking device with a fall detector in it, and it collects all kinds of wonderful information. Our number one piece of advice to everybody is make sure you have your advanced healthcare directives done, and just as important, that you've talked with your loved ones about what your values and goals are for healthcare. So if you're not able to speak up, there's somebody there that can work with your doctors to make sure that you get the care you want and don't get the care that you wouldn't have wanted.
And Mishka, last but never least.
Yeah, so, as we were joking about what is health law earlier and how we started circling back, I think 2 primary things. One is, as you look at professions and jobs, whether you're transitioning or whether you're starting out and getting ready to practice, I think be really open-minded and creative. The world is really innovative right now, and healthcare and health law and just the practice of law looks different than I think it ever has before. But I think the types of jobs you do are maybe cooler than ever before, because, like she said, there's so many ideas and startups and companies doing things that we never even imagined. So I think we all think about going into a firm, and you go into this like really strict area, and you think that the only thing you do is, facility certifications, and that is not the case. And so I think really be open-minded when recruiting during any phase of your life. And then also, because it's so innovative, really focus on every practice area. So, whether you're just starting, like, you have to know the corporate, like I'm doing BAAs like crazy, because we need to make sure that that data can be transferred and that you don't end up with $1 million fines because of information blocking by an IT company, and so focus on the real estate, the corporate law, regulatory law, labor and employment is really critical. Understand some of the criminal, even a little bit, as I was trying to call DAs earlier on today. It all intersects, and really the more you know and fully understand and have that foundation, the better we'll be, and you'll be able to move as quickly as like Diana and David were saying, because it's all moving so quickly and intersecting in a way I think we never imagined. We're not working in silos now. We need to all kind of understand at least a little bit of everything, and then collaborate as much as we can.
Very well said. Very well said. I like the collaboration piece. So thank you all for joining us this evening. David Godfrey, Diana Santos, Mishka Woodley, thank you all for sharing your insights with us and for the generosity of your time. To the Health Law Society Executive Board, in particular, Rachel Townsend and Alyssa Grinovac, whom I see in the audience, well done. And I also need to shout out to my hermanas in the law, Afro-Latina, and the Cafecito Network, Women Rise Up. And so thank you for joining us. It's been a pleasure. And I hope that you'll come back at some point, even though I'm graduating in May.
Congratulations.
Congratulations, and thank you for having me.
Thanks. Take care.
Thanks for being here. Bye-bye.
Bye.